HR Research presents our 2014 webinar series, delivering you the latest in HR news, legislative updates, and industry trends. As a provider of leading talent screening, management, and assessment solutions, we are here to ensure your company's continued success. Global HR Research. We redefine your HR expectations.
Hi everyone, my name is Megan Schoenfelter. I'm the Manager of Communications and Events here at Global HR Research. Global HR Research has been ranked as one of the top providers in the background screening space by HR Magazine for 4 years in a row. We attribute our success to the faith and loyalty of our clients, employees, and partners like our presenters today. We believe in better candidates, smarter hires, and incomparable customer support. Hiring is the most important thing you do. Trust it to Global HR. I'd like to welcome everyone and thank you for joining us today for our webinar entitled Ban the Box, How to Comply with a Myriad of State and Local Laws, presented by Pamela Devata, partner at Seyfarth Shaw, and Paul Kehoe, senior counsel at Seyfarth Shaw. Ms. Devata and Mr. Kehoe specialize in all aspects of employment defense, including counseling, training, and litigation. They hold a special emphasis on the Fair Credit Reporting Act and state laws affecting background screening. As well, Global HR Research strives to provide resources to our partners, clients, and those of you that are new acquaintances to us today. A follow-up survey will be sent directly after the webinar, where you'll be asked and able to give additional questions, make comments, or inquire about all of our solutions. This will be a silent webinar. If you have any questions during the presentation, please feel free to type them into the questionnaire box, and we will respond at the end of the presentation. The entire contents of this presentation will be available on our website within 24 to 72 hours after its completion. At this time, I'd like to turn over to our presenters, Ms. Devata and Mr. Kehoe. Thank you guys so much, and please enjoy our presentation.
Thanks so very much, and welcome everyone. We're thrilled to be here today. Before we get started with Ban the Box, how to comply with all of the myriad of state and local laws that are out there, let's start with a quick legal disclaimer. Obviously, both Paul and myself are lawyers, but nothing in this presentation today is meant to be legal advice or counsel. It's not intended to create any sort of attorney-client relationship, and the material is really just for informational purposes. Go ahead and read that at your leisure. We wanted to make sure that everybody was aware of that. We will have time for questions at the end. Please understand hypothetical questions. It's going to be hard for us to answer if they're based on factual specifics. But otherwise, we will do our very best to get to as many questions as we can. As they said earlier today, my name is Pam Devata. I'm a partner in the Labor and Employment Group here in our Chicago office, and I'm the co-chair of our Hiring Solutions Group. I've been dealing with areas of criminal history, ban the box laws, the EEOC criminal history guidance, and frankly, all things related to background checks and pre-hire for about 14 years now. I'm thrilled to be here today to talk a little bit about some of the initiatives going on, and very, very pleased to have one of my colleagues, Paul Kehoe, who is truly astounding in his expertise and brings some very new information based on his position with the Honorable Commissioner Victoria Lipnick as of just under a year ago, I should say. He had been at the EEOC for almost 4 years and then came back to Seyfarth. So, Paul, thrilled to have you here today to be doing the presentation.
Thanks a lot, Pam. And kind of assumed in that introduction is, you know, the elephant in the room. I was actually at the EEOC and played a hand in negotiating the 2012 criminal history guidance that is out there. And as a preface, I will always say, like all things in Washington, it could have been a lot worse. We did negotiate some changes from the draft guidance that was originally sent around. So, you know, while we certainly can recognize that there are going to be additional requirements on employers throughout the hiring process and how they conduct criminal background checks, it is a lot better than it could have been. And I know that's cold comfort to everybody out there. But I think at the end of the day, it is a document that's out there that certainly Pam and I believe that employers can actually comply with a good faith effort to do so. And at the end of the day, since most of this presentation is going to focus on the ban the box issues, it is important for employers to be cognizant of those differing ban the box issues, and I think we're up to about 13 or 14 jurisdictions right now that have banned the box issues, and the trend is certainly pointing in that direction for other jurisdictions to adopt them as well. So our goal in this presentation is hopefully to put you at ease at least a little bit, and to the extent that we can, and just provide a quick update on the state of the law as of today, and answer any questions that you have going forward.
So without further ado, let's talk about the agenda. The focus of this presentation is not just the EEOC criminal history guidance, but it's really going to be the Ban the Box initiative. And before we get started, for those of you who've never heard that term or don't know what that means, when we talk about the Ban the Box initiatives, and you'll see some of the states listed here on the local ordinances, what we're really talking about is when there is legislation that specifically prohibits or restricts an employer's use of asking about criminal history generally on the application. So it's banning the quote-unquote box that says, have you ever been convicted of criminal history, for example. We are going to be focused only on private employers. If you are a public employer, there are a myriad of other statutes and ordinances that are applicable. If you are a federal contractor, there are even some additional ordinances that may be available based on the fact that you have federal contracts. So we're really focused on the private employers, which is going to impact most of the people on the phone. This is a nice little handy reference of the states and the local ordinances for private employers that have already passed. We're going to go through in detail these. We're even going to talk about Washington, D.C., even though it hasn't passed. It has passed, but it hasn't been signed by the mayor yet. But Paul's going to give some more information about that. And then we're going to finalize this with best practices. We would be remiss without starting very briefly with the EEOC criminal history guidance. We have done a number of webinars on this specific topic. If you have not heard about the EEOC criminal history guidance and options for compliance and all of the myriad of things that it requires, I would highly encourage you to reach out to Global HR, to go to their website, and to get webinars that we've done in the past on this specific topic, so you can get more information. But because the EEOC is really the starting point, if you will, from the federal, I would say from the federal take, there is no federal statute that prohibits asking about criminal history on an application. So really the EEOC criminal history guidance is as close as it gets. So we're going to talk a few minutes about the Ban the Box recommendation, strong recommendation by the EEOC, and what that entails and why, and some of the other quick areas of the criminal history guidance before we dive into the state laws that specifically require it. At the end, in line with best practices, we're also going to give some options for compliance. But again, I would highly recommend that you go and get the other presentation if you want more information on that. So Paul, since you have been so intimately wed with the EEOC criminal history guidance, why don't you give us an overview of some of the requirements?
Well, thanks a lot, Pam. And, just piggybacking off of Pam's point, we have given, I feel, dozens of presentations on the EEOC criminal history guidance, and they have ranged from 1 to 2 hours. So this is going to be a very high-level kind of glance at what the guidance says and how the EEOC kind of shoehorns criminal background checks into the Title VII area. By way of background, essentially what the criminal history guidance says is there can be no bright line rules. If on the application or at any time during the hiring process, it comes to light that the company's policy is we don't hire any felons for any position regardless of what they were convicted of. That is exactly the type of scenario that the EEOC is focusing on right now. Those are, frankly, the easy cases, because it's going to be very difficult for a company to show that that type of blanket policy, if you will, is going to take into account the three-factor test that came from Green versus Missouri Pacific Railroad back in the 70s. And those three factors are the nature and gravity of the offense, the nature of the job, and the time elapsed since the conviction or the completion of the sentence. So really what this is going to, and this is an older part of the criminal history guidance. This has been in effect since then Chairman Clarence Thomas implemented guidance on this issue in 1987. So essentially what this requires employers to do is almost take a step back to stop, think, and justify a screening system for any particular job. A DUI is going to be related to a truck driver position, but it might not be related to a retail clerk position. So it certainly is advisable for employers to consider all of those issues. Now the question then focuses on the when to ask. When during the hiring process should employers ask this question? And from where the EEOC is coming from, if it's on the application, then a lot more people are going to be screened out because they check yes on the box on the application. And how the EEOC is looking at the entire issue is it's trying to find a disparate impact of discrimination. And disparate impact at the end of the day really is a numbers game. How many people were screened out, and what was the ratio of that to the people that applied? And if you're asking the question right when somebody applies on that initial contact between the applicant and the employer, then the pool of people is going to be so large that the disparate impact numbers are going to be skewed in favor of the goal that the EEOC is looking for. So imagine it like a funnel where, in the beginning you have 1,000 people applying for 3 jobs, and let's assume you ask that question and 950 people are screened out. Well, that's going to be a little bit of a problem. Now, if you narrow it down and ask the question later on in the process, there may only be 25 people that are impacted out of a different number, which will minimize the disparate impact. When the numbers get small, the EEOC can't prove its case, at the end of the day. So our recommendation, and frankly, the EEOC's best practice, is to move the question later on in the process. And by moving it later on in the process, the employer can kind of insulate itself from a disparate impact claim. And it's also not going to be requesting information that it doesn't use really until later on in the hiring process, because the EEOC is going to assume if you have the information, then you must have used it to make whatever employment decision that you came to. Now, I had mentioned that it was Clarence Thomas in 1987 who adopted the first EEOC criminal background guidance, and it did adopt that 3-factor test from Green versus Missouri Pacific Railroad. The one thing, or the major item that's different in the 2012 criminal guidance is the individualized assessment. And I am going to pass it over to Pam to talk about that.
Thanks, Paul. As we discussed, moving the criminal history question not only, as Paul said, will insulate you, it will also allow you to comply with the myriad of laws we're going to talk about today, the ban the box laws. And that's really the biggest push we get from employers who say, wait a second, I'm a nationwide employer, or I'm in multiple states, and how in the world am I going to keep up with all of these ever-changing laws? They're changing every week, it seems like, and we've had about 5 that have just gone into effect this year, that were passed this year. So given that, the recommendation to move the question either after interview or after conditional offer is certainly what we recommend, again, without giving legal advice. With regard to the individualized assessment, this is the area of the criminal history guidance from the EEOC that really was a sea change, as Paul said. This was really pulled out of whole cloth from the EEOC. We think based on a law that's in New York Article 23 of the Corrections Law, that is a statute. It is not just a regulation. It's not just guidance, but it specifically says employers in New York must look at an 8-factor test to see if the criminal history that they're using, either if it's self-disclosed or if it's on a background check, is specifically job-related and is substantially related to the job in question as well as a business necessity. With regard to individualized assessment, whether it came from New York Article 23A or it came from the EEOC's version of having an interactive dialogue, for example, like under the ADA, the Americans with Disabilities Act, what the guidance says, it's not a statute, it's not a regulation, what the guidance says is specifically that employers should do a case-by-case analysis and do an individualized assessment looking at all of these different factors if you're going to be looking at criminal history, the facts and circumstances surrounding the offense, how many offenses, the older age at the time of the conviction, evidence that the person performed work either before or after, rehabilitation efforts, etc. And the key is two things when you're talking about ban the box. Most companies who have a criminal history question on the application either use it in one of two ways. One, they look at it and they eliminate people carte blanche who have certain convictions. Felony conviction, carte blanche, they throw that application in the trash, for example. That's a bright line rule. That's what the EEOC guidance and frankly all of the ban the box laws that we're talking about want to prohibit, because you're not doing an individualized assessment and you're potentially making a barrier to those individuals who have criminal convictions from applying. That's the theory and the policy behind all the statutes we're discussing. The other piece of that is that employers will often say, okay, well, we're not going to throw those people out at the beginning, but we're going to look at it at the time the background check happens. And our answer is, well, absolutely. It's nice to have a question that you can ask that's legally appropriate, especially to determine if somebody falsifies. But if you're not going to look at it until later in the process, either after interview or after conditional offer, why in the world have the risk of asking so many people up front? Because it could be a barrier. And as Paul said, the numbers for a disparate impact case go up. So that's the reason why we thought it's important to talk about the EEOC criminal history guidance along with these ban the box. There is a real level of defense from a pure litigation standpoint that employers actually have if they decide to follow the ban the box clause, which in some states you are statutorily required to, and the EEOC criminal history guidance. We get a lot of discussions with the thousands of employers that we've spoken to about this issue in terms of logistics. The goal is you got to make sure you understand what state laws apply to you. If the criminal history guidance applies to you, which if you have more than 15 employers and you're a private employer, it will, and make sure that you then customize your program accordingly. So with that backdrop, we're going to go ahead and move on to the state law requirements that we discussed. And what's so interesting is in the last, I'd say, 4 to 5 years, we've seen this big wave of ban the box laws that have come up. Hawaii has been on the books for longer than any other statute, and it was passed over 10 years ago. And frankly, I think it was before its time, if you will. Hawaii's restriction is both for when you can ask about criminal history, but also when you can run a background check. So understand that if you're wanting to run background checks earlier in the process and you have employees in Hawaii, you're going to run afoul of the law if you do that. It is one of the 3 current jurisdictions that we have that are passed that have a requirement that you cannot ask about the question until conditional job offer. The other 2 are Baltimore, Maryland, and Newark, New Jersey. We're going to talk about those in detail, but it's not enough just to have an interview. You must have a conditional job offer when you are asking the criminal history question. There's also a limitation on what you can ask in terms of timing. So instead of asking, for example, have you ever been convicted of any conviction, in Hawaii you have to be careful and only ask going back 10 years back. You'll notice on the slides that we've put together here, we have information about whether or not there's carve-outs for federal and state laws. Well, we did this for a couple of reasons. One, because if you are a regulated industry, either by state regulation or federal regulation, you have other responsibilities. And we dealt with this, and we've seen the EEOC really respond to this criticism based on their criminal history guidance that came out. The EEOC says that if you are a federally regulated company or entity, then you should comply with the federal law because they're a federal agency and that's a federal law and they're equal. So, for example, FDIA, Violent Crimes Control Act for insurance, and other types of federally regulated companies that have very specific prohibitions on who you can hire. If you are a state-regulated industry, healthcare, for example, the EEOC guidance, at least the guidance, says doesn't matter. It's not going to be a defense. Now, we've heard many iterations from the EEOC spokespersons that they may take a different view on that, and they're not necessarily potentially going to go after people who are state-regulated. For Hawaii, and you'll notice for all the states that we talk about, most of the states have a specific exception where there is a state or federal law that requires an employer to either consider or prohibit certain convictions when hiring an individual. Then there's a carve-out or an exception, and Hawaii is one of those as well. Interestingly, when we talk about a couple of states, it depends on how the agency that is enforcing that law will view the carve-out, but we'll get to some of those states in a bit. So that's Hawaii after conditional offer, and we'll move on to our next state.
Up in the Northeast in Massachusetts, Massachusetts actually has one of the most, when you compare it to the other states, one of the most comprehensive ban-the-box statutes. At the end of the day, what the Massachusetts statute says is it is okay to ask after a written application has been submitted. Now that language gets a little squirrely, and the MCAD is going to interpret this to mean that you can ask the question anytime after the first interview, as opposed to what is specifically in the statute. Here's a good place to actually talk about how you ask the question, because some of these states allow you to ask the question during an interview. That is generally speaking, that is a bit of a questionable practice. It's always going to be better to ask the question in writing as opposed to ask it during an interview. So if your hiring processes allow interviewers to ask the question orally, it's probably a good idea to rethink that and ask it in writing based on the ban-the-box statute that is in effect in your either local jurisdiction or state. Now, the time limitation in Massachusetts, you can ask about misdemeanors you cannot ask about misdemeanors that are over 5 years old unless the individual has been convicted of another offense within 5 years. Massachusetts is one of those states that on the application, if you do have a question, this is going to have to be, these caveats are going to have to be in the directions added to the application that lets Massachusetts applicants aware of what can be asked, what can't be asked, what time limits are there, and so on and so forth. Massachusetts does have the full carve-out for federal and state laws. So that means in Massachusetts, technically, if you want to ask the question on the application, and the question is limited to those issues where federal law or state law prohibits the hiring of an individual, then you can do that on a ban-the-box law, on an application. That may not be actually the best practice, but it is certainly permissible under the statute. Some other unique characteristics to the Massachusetts law: you can't make any inquiries about first convictions for drunkenness, simple assault, speeding, minor traffic violations, or disturbing the peace. Those are the great big no-nos in Massachusetts for employers to avoid. Also, with regards to prior arrests, court appearances, and adjudications, and all cases of delinquency or they occurred when the individual was a child, those also can't be asked about. So that seems to be a general requirement of most of the state ban-the-box laws. The child, offenses committing while an individual was a juvenile. So that should probably also be a carve-out in on the applications, certainly in Massachusetts and frankly in many other states. We will next turn to Minnesota. Pam?
Minnesota. And one real quick thing about Massachusetts too, the MCAD, the Massachusetts Commission Against Discrimination, right, they interpret this, as Paul said, they interpret it different than the plain language of the statute. Minnesota is similar in interpreting the actual statute a little bit differently than the plain language of the statute. Minnesota has a full ban-the-box. It's one of the states that has the ban-the-box. It just went into effect of January of this year. Basically, it says that you cannot ask about criminal history until either the applicant is selected for the initial interview, or if you're not doing an initial interview at the time the person has a conditional offer. There's no time limit that they have that restricts for when you can ask the question. What's interesting is that there is a carve-out for federal and state laws. However, it appears that the Minnesota Human Rights Division is not necessarily abiding by that call-out for state law and federal law, and has been investigating companies after January of 2014 who may also be federally regulated. So remains to be seen, but so if you are one of those federally or state regulated companies, you should talk to counsel, internal or external, to make sure what you're doing is kosher. But the law itself says after an initial interview or conditional offer. We get questions all the time of what does that mean? So for example, if somebody has a phone screen, is that an initial interview? And it really depends on your specific customized process, but most of the time, most of these state laws deal with the fact that an individual can have, if they are meeting basic and minimum qualifications and they're interviewed for the position and they're moving on to the next step, that's going to be enough in almost all cases. So be careful a little bit about Minnesota if you are federally regulated or regulated by the state. If not, understand you got to take it off that application, but you can move that question back into the process. So we're going to move over to the East Coast again and go to Rhode Island.
And Rhode Island also has a newer ban-the-box statute, went in effect at the beginning of this year, so it's only been on the books for about 8 or 9 months. And this one also is fairly simple and straightforward. When can an employer ask? Well, an employer can ask either during the first interview or at any point thereafter. This is when the recommendation that the question is actually asked in writing is worthwhile to follow. Is there any time limitation in Rhode Island on how far back an employer can ask? No, there's not. An employer can go back 40 or 50 years if they want to, though that may not be the best course of action when you think of the ban-the-box law in relation to other laws. Rhode Island also has the full carve-out for federal and state laws, so an employer on the application may ask whether or not certain individuals or whether or not all applicants have been convicted of certain crimes that would be an automatic bar to hiring those individuals from certain positions. It may get a little tricky to maintain a system like that, but it's certainly possible to do. And we will move over back to the Midwest, to the great state of Illinois, who just recently signed a ban-the-box, whose governor just recently signed a ban-the-box statute.
Thanks, Paul. We've been waiting for this, and I'm in Illinois, in Chicago. This law actually is not in effect yet. It has been passed and it has been signed. It took the governor quite a while to have this bill on his desk, but it is signed and goes into effect as of January of next year. So if you weren't aware of it, make sure that you are. The law is actually pretty broad in Illinois, and what this ban-the-box statute says is similar to some of the other ones that we've talked about, which is after an applicant is selected for the initial interview, or if they're not going to be, or they don't have an initial interview, after the conditional offer. It doesn't mean that the interview has to take place. And the way I read this statute and we interpret this is that after the individual has that initial interview, has been told that they have that initial interview and they've been selected, then you can ask the question. It only applies to individuals who have, employers who have 15 employees or more. There's no time limit restriction on how far back you can ask the question. Understand Illinois has another law, the Illinois Human Rights Act, that talks about and specifically prohibits asking about arrest record information. One thing we should talk about for all of these laws is, the EEOC guidance abhors the use of arrest records and frankly says that an employer who uses arrest records in making an employment decision will have a per se disparate impact. So when we're talking about the criminal history question, we're really talking about criminal history that is not arrest. So what do we mean? Generally speaking, convictions or things that are currently pending. Most states, there's a couple that do not, but most states have an exception for those that are currently pending. Somebody was arrested 2 weeks ago and the crime is currently pending. There is, like most of the states we're talking about, a carve-out for state and federal law here, and it has not been interpreted any differently, probably because the law hasn't gone into effect yet. So we're now going to move over to the newest law that was just passed. I think it hasn't even been 2 weeks, or maybe just 2 weeks now in New Jersey. Paul?
Yeah, Pam, I think that's right. I think Governor Christie signed this bill maybe 2 or 3 weeks ago, and it is, although the New Jersey legislature had passed it some months ago, but it has just been signed, and it will go into effect March 1st, 2015. The New Jersey one is actually a little bit interesting for how, especially for employers who function in Newark, New Jersey as well. I'll get to that in a minute, but I think it's worth pointing out that this one is a little bit different. So as far as when an employer in New Jersey can ask the criminal background question, it has to be sometime after the first interview. And it only applies to employers who have over 15 employees. Now, one of the interesting parts of the New Jersey law is, how far back can you ask about? Well, that's going to depend on the crime, and it's going to depend on the seriousness of the crime. So there are going to be some crimes that you can ask forever, and I believe murder falls into one of those. And there are going to be other crimes more on the misdemeanor side of the ledger where the time limitation is going to be a little bit shorter. Now, New Jersey does have a carve-out for federal and state laws, meaning that the ban-the-box statute doesn't apply for those issues. But one thing, and it's actually not on the slide, New Jersey does actually preempt all other local ordinances in the state of New Jersey. So once this New Jersey state ban-the-box statute goes into effect, it's essentially going to preempt the Newark ordinance. Now, the New Jersey law, it's going to, preempt the ordinance to the extent that it was adopted before this New Jersey state bill was adopted. My guess is probably that the Newark City Council will wait until March 2nd, 2015 and adopt their ordinance all over again. But at least there is cause for concern / celebration maybe for those employers who are actually in Newark, who at least for a blink of an eye may not have to comply with the Newark ban-the-box statute, at least maybe not on March 1st, 2015. And moving down the East Coast a little bit to Washington, D.C., several months ago, the D.C. City Council passed the Fair Criminal Record Screening Act. It is currently still pending, but it is sitting on the mayor's desk waiting for him to sign it. In true Washington, D.C. form, there's pretty much nobody in any office for the entire month of August. So the mayor probably hasn't gotten around to actually putting the pen to paper yet to sign this, but there's no doubt that at some point in the near future, the mayor is going to sign this bill. And the law, once it's signed, it's going to prohibit employers from asking the question until after a conditional offer has been extended to the applicant. It's only going to apply to employers who have at least 10 employees, and there is no time limitation on how far back you can ask about criminal convictions. Now, D.C., essentially being a federal territory, does have the carve-out for federal and state laws. So there are instances where D.C. employers will be able to ask the question without getting in trouble. But there are another couple things that D.C. employers have to be cognizant of. The first one is assuming, and we are all assuming this, that employers are complying with the Fair Credit Reporting Act. An individual who's been screened out and who's received the FCRA notice can request from the employer the reasoning behind the decision not to hire the person. And there are 8 to 10 different factors that the employer is going to have to provide information on. And it's going to be a time-consuming process, and for DC employers, probably hurt or at least slow down the process, the hiring process for individuals. All that being said, it is going to be required under DC law that essentially this essay has to be written for employers to screen somebody out. And also one thing to note, there is a sliding scale for fines depending on the size of the employer. The bigger you get, the more you have to pay. And the fines range, from hundreds of dollars to several $1,000s. So that's something for employers to be concerned with, when they are conducting background checks on their applicants. And that is actually the end of the state-related presentation. We're going to go a little bit north to the great state of Philadelphia. Pam?
Thanks, Paul. So in addition to the states, as Paul indicated, we've got a bunch of local ordinances. And so cities and municipalities have taken it upon themselves to also enact their own versions when the state, for example, has been slow or has been unable to pass legislation based on markup or industry groups, lobbying, things like that. We've got a number of these as well, and some of them apply regardless of how many employees you have in the state. Some of them apply only if you have a specific number of employees in the state. Some of them only apply when you're hiring in that specific jurisdiction. The first of which is Philadelphia. That Philadelphia, if you are an employer who is hiring in the city of Philadelphia for a position in the limits of Philadelphia, you cannot ask until after the first interview. First interview, again, not defined. It could be a pre-screen, could be an in-person interview. It only applies if you're going to have 10 employees, although we think the 10 employees doesn't necessarily need to be in the city of Philadelphia. There's no time limitation. The other thing that's interesting is that while it does have a carve-out for the federal and the state requirements, and we don't believe it's being administered any differently there, like some of the other states, you can ask about pending arrest, and there's a specific information in the statute that allows you to ask about things that are currently pending. So if somebody has a pending crime and you want to ask about it, unlike Illinois where it's totally restricted, you could ask about it in Philadelphia. So understand that. The next jurisdiction that we've got a local jurisdiction is Buffalo, New York. Very, very similar to Philadelphia. You can ask about this after the first interview or thereafter. So it doesn't say you have to ask about it after at the first interview, but anytime either during that interview or afterwards. Again, as Paul said, asking during an interview usually becomes a he said, she said. 2 years, 3 years later when we're defending a lawsuit, it's very hard to have summary judgment. It's much, much better to ask the question in writing in a separate document that says at the top to be completed after, and you can fill in the blank after interview or after conditional offer, for example, if you're in states that have that requirement, and or if you just want to limit your risk even more. It applies to individual companies who have over 15 employees. Some of these statutes apply only if there's one employee, so understand that. But I think most people on the phone have 15 or more employees. Again, no time limitation, and there is a restriction with the federal and state laws I'm going to move a little quickly just because of time. One thing to remember in New York, and this goes for any employer in New York, is that you do have to comply with New York Article 23A of the Corrections Law. And that was the regulation we mentioned earlier that specifically restricts an employer from using criminal history unless it looks at 9 different factors that are delineated in the statute. Mitigating factors, public policy, the nature and the gravity of the offense, a lot of the individualized assessment factors that the EEOC has adopted as well. So make sure that you're complying with that. And we're going to stay in New York and pop over to Rochester. Paul?
Yes, and in Rochester, this is a newly adopted ban the box ordinance. It was adopted, I believe, in May of this year, and it will go into effect just before Thanksgiving in November. So there are still a few months for employers to scrub their application and get ready for it right as the turkey is cooking in the oven. When to ask in Rochester? This can be after the first interview or after a conditional offer. The Rochester ordinance is a bit more restricted when it comes to employer size. Any employer with more than 4 employees is going to be subject to the ban the box restrictions. Is there any time limitation? Not in Rochester. As very similar to Buffalo, there is a carve out for federal and state laws, as well as employers are going to have to consider New York Article 23A when they're choosing whether or not to hire an individual. So that is going to conclude New York, and we're going to head out west to Seattle, Washington, which actually, almost like the Massachusetts law, is very detailed, and there are other certain caveats that Seattle employers have to be aware of. When can Seattle employers ask the question? That is essentially after the employer's completed an initial screening of applications to eliminate unqualified applicants. Now, that's language lifted directly from the ordinance, which seems to indicate that the first interview or thereafter is fair game for employers in Seattle. Now, as far as what employers are covered, any employer with more than 1 employee. So that's going to, frankly, cover just about everybody unless you're a true sole proprietorship, when you're probably not going to be asking yourself whether you have a criminal conviction. Now, there's no time limitation in the Seattle ordinance, but under Washington law, there is a 10-year restriction on what you can ask for. So for all those employers in Seattle who are looking to update their application, that's one of the caveats that's out there, and frankly, that's not new. So Seattle does have a carve-out for the federal and state law issue, meaning that those employers can ask about certain convictions where convictions for those certain crimes prohibit the employer from hiring that person for a certain job. Other little curveballs in Seattle is an applicant can include a criminal conviction that's where a certificate of rehabilitation has been granted or any other equivalent procedure based on a finding of rehabilitation. So Seattle really focuses on rehabilitation. If there's a certificate, then applicants don't necessarily even have to say that they've been convicted or something. Also a big point, kind of a Fair Credit Reporting Act type point, but Seattle employers have to wait 2 business days after informing the applicant of the adverse employment action based on criminal history. This is essentially a built-in kind of opportunity to be heard, period, if the applicant wants to reach out and touch base with the employer. So it is a process-related requirement to wait 2 days before actually taking the adverse action.
Real quickly on Seattle, obviously, as Paul mentioned, with the Fair Credit Reporting Act, you have to wait a reasonable period of time between a pre-adverse and adverse employment action. And so, query whether and how that works when you're dealing with the Seattle ordinance as well. And for a lot of employers, it's been challenging because now you have to do more than you normally would do with the regular pre-adverse and adverse action under the Fair Credit Reporting Act. So if you do business in Seattle, make sure that you are talking to your background screening provider, talking to Global HR, making sure you're talking to your counsel to make sure your compliance is set up with those adverse actions, because you don't want to run afoul of that. So now we'll move to Baltimore. Baltimore is one of the other jurisdictions that has a specific prohibition on asking the question until after the conditional offer. So remember, you've got Hawaii, you've got Baltimore, Maryland. We're going to talk about Newark, New Jersey, and as soon as that Washington, D.C. Ordinance is passed, excuse me, I should say once it's signed, which it will be, then you're going to have that one as well. But again, it's not after the interview, it's after conditional offer. It applies if you've got 10 employees or more. There's no time limitation. Baltimore, Maryland is one of the shortest statutes that we've seen. It's like 2 paragraphs. It doesn't have a lot of information, doesn't have a lot of legislative history. It was passed very quickly. And it's been in effect now for a little bit of time. So understand that if you are in Baltimore, there is a carve out for state and federal, but this is a conditional offer state, jurisdiction. So if you do have business in Baltimore, you may want to consider, similar to if you have employees in Hawaii and or Newark, New Jersey, although we'll talk about that preemption again, be careful about that. Newark, New Jersey, as Paul said, this may go away as of March of 2015. Newark, of course, is in New Jersey. The New Jersey law, as Paul said, arguably will preempt any other statute that was, doesn't even have to be more restrictive, any other statute that deals with criminal history, which this one would. Very unclear if Newark is going to do something. We think very much that it might. But currently, until March, or until there is any other ordinance that is passed, employers who have more than 5 employees in the city limits of Newark, New Jersey. So if you have 4, it doesn't count. If you have 2, it doesn't count. If you've got 30,000 employees, but you've got 2 in Newark, doesn't matter. Doesn't apply to you. If you've got 5 individuals working in the city limits of Newark, though, you have to wait until after conditional offer of employment to ask the question. So Newark is, New Jersey, frankly, is very different than other states. Instead of having misdemeanors and felonies, it has indictable offenses and non-indictable offenses. And so it's got even a newer type of criminal history. And so for indictable offenses, in Newark, you are not allowed to ask about offenses that occurred over 8 years after the conviction or completion of the sentence. So even after the conditional offer, you still have a limitation on what you can ask. Same thing for disorderly persons and municipal violations. Those are non-indictable offenses. You can only go back 5 years. So be cognizant of that as well. Newark has all sorts of requirements for adverse action that are very different from the Federal Fair Credit Reporting Act. An employer must wait 10 days before the adverse action. They have to give an additional notice with the pre-adverse action and then wait additional time to consider more information that a potential employee or applicant may have at that point. It's a very, very detailed process. Most background screening companies are aware of this, but are remiss because they just can't comply with assisting their employers with this. So make sure you're aware of your obligations if you are in Newark, but understand this all may go away. Quickly, we're going to do San Francisco and best practices, and then we'll get on to the questions. Paul, San Francisco?
So in San Francisco, when can an employer ask the question? Well, anytime after the first interview or after a conditional offer. The major caveat in San Francisco has to do with the number of employees. And it essentially, if any employer has over 20 employees, no matter where they are across the country, if they're hiring somebody in the city limits of San Francisco, this applies to you. So this isn't limited by the 20 employees in San Francisco. This is 20 employees anywhere as long as you're hiring in San Francisco. Then the ban the box ordinance applies. The time limitation for San Francisco is 7 years, and it does not contain a carve-out for federal and state laws. There are also prohibitions on certain kinds of inquiries, and they're listed here in the bullet points. And it also doesn't let you take an employment action if a conviction happened more than 7 years ago. So It's not just about asking the question in San Francisco. It's about using any information that you receive in San Francisco. There are other additional notice requirements that are contained in the San Francisco ordinance, and there's also a 7-day response period where employers can't take the adverse action until seven days has gone by. And there's also a notice form, an OLSC form that they have printed, which has to be printed in various languages, depending on how many individuals within your company speak a certain language, and some other requirements based on that. So San Francisco is probably going to be the most difficult one to comply with because it has so many rules on what you can and what you can't ask about, and then what you can and what you can't use if you receive any information from a CRA. Moving into our best practices, Pam?
So we've given a lot of information on all the different myriads of laws, the EEOC criminal history guidance, all the state laws and all the local ordinances. So what does this mean? It means that you absolutely can still ask about criminal history, but you need to know when you're going to do it. So the best practice is to do the question after the conditional offer, unless you have a federal or state law reason to do it earlier, if you are federally or state regulated, for example. This way you're going to meet all the ban-the-box laws that we have currently passed, and frankly any others that will be passed. You're going to mitigate your risk in the most genuine fashion in terms of numbers. You don't have to do this in some states, but if you want a one-size-fits-all practice to comply with all of the laws, if you're a nationwide employer, you might want to consider that. Don't ask about results that didn't result in a conviction. You're going to run afoul of the EEOC guidance, as well as, of course, some of the state laws we've talked about. Sealed, expunged, restricted, juvenile, pardon, impounded. There's many other words that we could use. If you're not allowed to use the information, don't get it from your background screening provider and don't ask about it. These are things that get people in a lot of trouble. We still consider that you should ask the question, but it's a question of when you ask and what you ask. Make sure you do a job-related inquiry. What that means is, as Paul said earlier, if the person is going to be not going to be driving for you and the person has a DUI, likely that's not going to be job-related. However, if the person is going to have access to personal information or customers or in customers' homes, for example, and has theft or fraud or violence, that might be job-related, and that's what you need to look at to see what convictions are going to be related to the specific roles and positions. Consider a centralized background screening rule. What we mean by this is have one person that's in charge of issuing and asking the questions and getting that information back so that you can make an argument, one, that you're consistent, and two, that you are complying with the individualized assessment requirements of the EEOC and New York Article 23A and all the other discussions that we've talked about in San Francisco and in Newark and in other states that have some of the restrictions. Review your policies and procedures. If you do have an employment application, whether it's in paper or electronic, and people forget. Sometimes they fix their electronic by taking off the criminal history question, but they forget that some people might actually come in and use a paper app. Both of those should be reviewed and take that criminal history question off of the application if there's any way you can. And finally, follow the Fair Credit Reporting Act, the FCRA, and specific adverse action requirements of each and individual state. If you do have questions about that, feel free to reach out to Global HR and or to us, and we'll certainly try and help. Our contact information is here. And with that, I think we've got about 8 minutes left for questions. So I'm going to pass it back over to Global HR so that we can get some of the questions that have been asked. Thanks very much.
Yep, Pam, we have 2 questions actually for you guys. First one is, do you have any thoughts on how this all applies to temporary and full-time staffing agencies? Would asking after the initial interview in states where allowable be applicable after the first assessment interview with the agency, even if position is not yet identified?
Yeah, this is a very tricky question, and I actually had a discussion about this just yesterday. And the answer is it really is going to depend. It depends if you're a temporary staffing agency who actually hires individuals and then places them, or whether you put people on a roster, for example. And if you put people on a roster and says that they're available to work, when can you ask that question? It's a little bit unclear, and there's some very bad other pending laws that haven't gotten a lot of muster yet, so we didn't mention them, but that talk about after a conditional offer of employment. And the issue is with the states that have the conditional offer of employment, I think those are the states that are the toughest to comply with it for a temporary staffing company. I think there's a very good argument that if you ask the individual the criminal history question after they have been, for example, put on your roster, or you've decided that they meet the minimum qualifications to work with your company, you're probably going to be in good stead. But the government could disagree, so you should get some true legal advice on that. The other thing is, however staffing companies deal with I-9s and E-Verify, that's going to be similar, because remember, you can't do that until after the offer has been given. But that's a very, very good question.
Okay, and our second question is, what is recommendation for asking about convictions in writing at some point after the first interview? Should there be a form for this, and do you think it's advisable to never ask but still conduct a criminal background check?
So I think we partially answered this, which was, but let's make it more clear. We absolutely believe that there's benefit to asking the criminal history question. And the reason is, if you don't ask, you cannot delineate who is not forthcoming and who is potentially falsified. There's no requirement, unless you're a regulated entity, but for most private employers, there's no requirement that you ask. There are some employers that choose not to, and they just run the background check because the state laws are difficult to comply with. But what we would say is then you lose the opportunity to eliminate those individuals who have falsified or who lied. And to many employers, that's very, very important. As Paul indicated earlier, we always recommend that you have it in writing on a separate document and a separate form, so that you can say, for example, if it's in one of the states that has a call-out that you're not allowed to ask about certain things, that you can have those restrictions. One thing of note that we didn't mention here, that there are a lot of other laws, California, for example, Washington, for example, Connecticut, that have other restrictions on what you are allowed to ask about criminal history. So it has nothing to do with ban the box. It has nothing to do with when you have to ask that question. But there's restrictions, like, for example, in California, about asking about certain marijuana convictions over 2 years old, or that in Connecticut that are annulled or erased, and you have to have the definition of what erased means, for example. So understand that there are some other restrictions that are not just ban the box.
Okay, we have one last question come in, and I think we have just enough time for it. What if an applicant offers early information in the interview process? Should they probe, or should they just document it and then don't follow up on the information?
Yeah, that's another great question. And our general response, again, without giving legal advice, is to say something to the individual. It's no different than shutting the door, if you will. We call it in our training classes, which is somebody comes and tells you that they have a medical condition. What you say is, thanks for bringing that to our attention. We don't take that into consideration until later in the hiring process, if it's criminal conviction, or ever, right? So if somebody says that they have diabetes, for example, you would say, thanks for bringing that to our attention. We don't take that into consideration in making our hiring decisions. So similar, if somebody says they have been convicted of a felony conviction of burglary, you would say, thanks for letting us know. We don't take that into consideration unless and until you make it further on in the hiring process, at which time we'll want to know and ask information about your criminal history in accordance with the law, something like that. But I would not probe at that point in time, especially if you don't have a process in place to do so. And you want to make sure you really do shut that door, so that that person doesn't, if they don't get moved on to the next round of interviews or to the next process in the hiring process, they can't come back and say, well, I told them I had this conviction and that's why they did this, for example.
Perfect. Well, that was our last question. Thank you guys so much for joining us, and thank you, Pam and Paul, for presenting.